Ladies and gentlemen, I have something just hot off the press. In fact, I just came into possession of this late information. I haven't even had time to comb my hair. I still have my pajamas on, so bear with me just for a few moments. I have just awakened from my sleep, so I'm not altogether fully awake, and I may make some mistakes and stumble just a little, but please bear with me. What I want to read to you is an apt description of the latest book by Mr. Stokes entitled The Shooting Salvationist. And by the way, if you will look at the cover of the picture of J. Frank Norris, you will see that that picture has been altered. That tells you 1,000 words in just one picture. Now, here's what I've discovered. And this happened in my lifetime. There was an emerging, self-appointed gangs of people in the early 30s for various reasons in different places would establish what became known as a Kangaroo Court. I just want to read you some of the characteristics of a Kangaroo Court. And I must say up front, that precisely fits the description of Mr. Stokes' Shooting Salvationist. A Kangaroo Court is a colloquial term for a sham legal proceeding or court. The outcome of a trial by Kangaroo Court is essentially determined in advance, usually for the purpose of ensuring conviction, either by going through the motions of manipulated procedure or by allowing no defense at all. See, that's the mentality of Mr. Stokes. He doesn't want to recognize the defense as being credible. He brings it out in his book. A Kangaroo Court's proceedings deny new process. Underscore that word process. Process rights in the name of expediency. Such rights include the right to summon witnesses. That's the right in a legitimate American court system. Mr. Stokes does not want to recognize the witnesses that verify J. Frank Norris's testimony in that court in Austin, Texas in 1926. Such rights include the right to summon witnesses, the right of cross-examination, the right not to incriminate oneself, the right not to be tried on secret evidence. Tell us, Mr. Stokes, where your real evidence comes from. You have already told us that you heard all of these weird stories about J. Frank Norris. Tell me where those weird stories came from. The right to control one's own defense, the right to exclude evidence that is improperly obtained. Oh, what powerful language. Irrelevant and by the way, Mr. Stokes, you have utilized a lot of irrelevant evidence that just will not stand the heat of day or inherently inadmissible. Hearsay, that's exactly the premise of Mr. Stokes' book. Most of it is built upon hearsay. Okay, attorneys, take up and take notice of what I've just said. The right to exclude judges or jurors on the grounds of partiality or conflict of interest, and the right of appeal. Mr. Stokes uses Kangaroo Court methods, and I say this as kindly as I know how, you who purchase his book, you, my friend, have been snookered. And I close with saying there's more to come. Just give me time. God bless America.